before everything gets closed out. Good morning. You're Linton Arsenault? And Mr. Arsenault, are you currently sick?
Ma'am?
Are you sick right now?
No, ma'am.
Would you pull that down for me just so, there you go, I can hear you better in the hearing. And Mr. Arsenault, in cause number 24, DCCR 2190,
This is already a huge deal failure to comply with sex offender registration is not seen as a small mistake. Courts treat it as a public safety issue because registration is how the system tracks someone. Do you think these laws are about accountability or control?
was previously in court, entered a plea of guilty to failure to comply with sex offender registration requirements. The agreement was for a cap of 10 years in the institutional division of the Texas Department of Corrections. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor. None from the defense.
All right, Mr. LeBlanc, you may proceed.
Judge, reading this PSI report, it does appear that he has a lengthy criminal history. I would say the top part of that had a lot to do with him being homeless at the time. The criminal trespasses that were all dismissed, all those. It looks, defense work to me, it looks worse than it. I've seen worse. Although he does have some extensive history. This case that he has to, the reason he has to report was from a case in 2023 that evidently he got the minimum 2 years, and I wasn't part of that case. He got the minimum on a, and I don't think he went to the penitentiary. He stayed in county jail on that. That's my understanding, Judge. And I'm not making light
on that case. He did, yes.
And in this case, Judge, I watched the video that he did go in and try to report. I don't think he went back the next year is what it was. I think he reported initially.
I brought everything in myself.
And I watched the interview, and it was confusing to me as to what he had to do. And I don't know. I think he probably just got frustrated and just didn't go the next year. And that's wrong. And that's what we're here before the court for. It's been capped, and I appreciate the prosecutor doing that. I would ask the court to.
The defense is not denying what happened. They're trying to explain it as confusion and frustration. But in court, saying I did not understand is risky because the law expects you to ask questions before you stop complying. Do you believe that explanation?
Sentencing towards the lower end, Judge. I don't think 10 years, 10 years is a long time for him not reporting for that. So Judge, I would ask that you consider, he doesn't want a trial, he doesn't want probation. He said that he was upfront with the court. Probation's not an option in his mind, and he's ready to do his time, whatever the court deems is fair.
All right. Thank you. Mr. Hoffpower.
I want to direct the court to page 1 of the PSI, really it's page 2, but to the defendant's version, I don't believe that he's taking responsibility for it. He says, I think that's a hedge. That's not I did it, and he said he wasn't told somehow. He knew he had a report. He did, but he did initially, but then didn't. I'm not really sure what the court thinks of that. I know what I think of that is that it's a hedge, and that he thinks that he gets to decide whether he reports or he doesn't. I don't care how long he got initially. This is part of being a sex offender is reporting. We need to know where you're at. And if you aren't, then you're supervising yourself, and that's the problem. So the only reason I think the state, and it's up to the court, obviously I don't agree with the lower end. I agree we have to know where he is, because if we rely on him to do it, he ain't gonna come. And he's not gonna report. So we need to do the maximum of 10 years that we will know where he's at for those 10 years. That's the only way we can be safe.
Thank you, Mr. Hoffpower. So, Mr. Arsenault, I noticed the same thing that Mr. Hoffpower did in your version when you talked to the probation officer. It says, I stopped going up there because when I went to court, the attorney told you were signing for 2 years, TDC. He didn't tell me anything about the registration part.
No,
You didn't say that?
no, ma'am. I did say that.
Okay, so when you were in court, I looked it up to make sure that we didn't miss something and that you weren't told about it. when you were in court with Mr. West, he went over with you the sex offender registration admonishment, and that's your signature right there, right?
Yes, ma'am.
Okay.
But he didn't explain nothing to me.
But you were told by him and by me that you had to register, and you obviously knew you had to register because you went and registered the first time. So saying you didn't know you had to register when you actually registered doesn't make much
I went
sense.
in front of Judge Stevenson.
This is where the judge points out the contradiction. You signed the paperwork, and you registered once. So claiming you did not know does not hold up when a judge thinks someone is avoiding responsibility. Sympathy disappears fast.
What is?
No, you went and registered at the Beaumont Police Department. You went on July 20th of 2023 for your initial registration as a sex offender. So you did know you have to register because you went and did it. You just didn't do it after that.
Yes, ma'am.
Okay. All right, so I'm going to find that you entered your plea of guilty, and also, in addition to all of that, just so everybody's on the same page, this is your 8th felony offense. You have 7 prior felony offenses going back to 97, where you got a probation, got revoked, got 5 years in prison. You've been to state jail, looks like twice or 3 times. You went to prison again in 07, or actually that one ended up in 10 for 3 years. You went to prison in 16 for 4 years for an ag assault with a deadly weapon, and then you went for 2 years on that sexual assault case. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirement. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. LeBlanc. All right, good luck to you, sir. You can go back with the bailiff.
Thank you.
Ma'am, you're Crystal Vogan. And Ms. Vogan, you were here yesterday for sentencing in cause number 25 DCCR 0026. Just so the record's clear, I rejected that agreement based on your criminal history. The fact that it was a deferred probation, I feel like with your criminal history, it is at this point, if you're going to accept responsibility, time for a conviction. You were going to be able to leave yesterday. There was an incident in the courtroom. Based on all of that, I raised your bond. Mr. Lewis asked that we bring you out today. Mr. Lewis, what is?
Well, Judge, yesterday afternoon, I went and spoke with Ms. Bogan about everything going on with the case. One, she did apologize to me, and she said, of course, when she had the opportunity, she wanted to apologize to you, to the court, for her actions yesterday. Did explain to her as far as where we were as the case, the rejection was there on the deferred. You did.
8 years is a serious sentence, not the full 10, but still heavy. The judge is not only looking at this mistake, but the entire felony history. Do you think past crime should matter this much in sentencing?
Kind of, but at that point, it would have to be a straight probation with the restitution if she was to be on any type of probation. She told me she was more than willing to accept that. She understands how it may affect her with her job, but if she wanted to still, if that opportunity was there, she wanted to definitely take it.
Mr. Hoffpower?
Judge, in light of all that the court's already mentioned and cited, we're going to leave it to the court, but we would not be inclined to put her on probation after the way she acted and due to her criminal history. So we would. If the court wants to allow her to do straight, that's fine, I understand.
Yeah, well, that's what your argument was yesterday.
It was.
To continue, for me to go forward. So, I mean,
True.
the most important thing to me, obviously, I don't know that you deserve a probation at all with your criminal history. But as I said yesterday and today, it is time for you to have some responsibility and some consequences for continuing to commit felony offenses. You know, it's great that you can finish a deferred probation, but at some point, you got to quit getting felony offenses and quit violating the law. And so I don't think that's fair at all. So what I can do, I have the paperwork still from yesterday. And if you guys would want to agree to a convicted probation, I can make that modification on this punishment recommendation. And then I can kind of reinstate everything up to the plea and all of that, so we don't have to go through all of that. So I'll reinstate everything we've done prior to today, make that modification on the paperwork, and go forward with sentencing. Is that everyone's agreement?
That's what I'm saying.
That's fine with us.
The modification will be a 2/5. It will be a 5-year probation. It will be a convicted 2/5. I am going to, I'm not inclined to order a fine because I want that restitution paid. So I'm going to mark through that. So with everyone's permission, I'll make that change, and that's what everyone's agreement is. Is that correct? And it is, I want to make sure you understand that this is now your agreement. And so if I follow an agreement to give you 2 years in the state jail, but probate it for 5 years, order that restitution, you can't change your mind later. This is your agreement. Is that correct? Okay. All right, then what I'm going to do, let's see, restitution. And the restitution will be that 10,000. And that's everyone's agreement as well, correct?
Yes,
Correct.
All right, then at this time, Ms. Vogan, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of property. Sentence you in accordance with your new agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $10,000 fine, restitution, and to follow all of the rules and conditions of probation. If you do this, this is still a good opportunity because you will be able to serve that 2-year sentence while you're out on probation instead of in the state jail prison. The other side of that, though, is if you violate any condition of probation at all, you will be brought back into court and you will be facing that 2-year sentence that I just gave you. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. Good luck to you, ma'am. Do you need my PSI? I printed it out. Okay, you've got everything. I'm sorry, I just printed my PSI, but y'all can throw that away.
Orders, but I have them.
You have them? Okay.
Judge, if it's okay with the court as well, I did want to apologize to you.
Yes, ma'am.
I'm very sorry. I was going through a lot, which I understand is not an excuse. And I do want to apologize for my actions and behavior.
I appreciate that. Make sure that while you're on probation, that you don't let those emotions also get in the way of you being cordial and doing what you're supposed to on this probation, as well as the other one that you're on, because that just in itself could get you right back in here. Even if you disagree with whatever they're ordering, if you disagree, you disagree. But you have to do everything they said. You have to be cordial. Thank you for your apology. You can go back with the bailiff. Thank you. Good morning. You're Zully Valicia. And Ms. Valicia, you were previously in court and entered a plea of guilty to burglary of a habitation, a second-degree felony. This is 24 DCCR 1364. The agreement was for a cap of 7 years in prison. I've received the pre-sentence report and reviewed it. Has everyone had an opportunity to review it?
Yes, Sharon.
Yes, sir, we have.
Any additions or corrections?
The judge is making it very clear that this agreement is final. Plea deals are binding in criminal court. Once probation terms are accepted, violating them can bring the prison sentence back. Immediately would you take probation, knowing one mistake could send you in?
I've reviewed the PSI with Zuli. I know that obviously her version, the court has questions about that, and so I would allow her to address that if she does wish to move forward in hopes of obviously us arguing for the probation.
So here's the thing. If you say you didn't do it, you don't get to say I didn't do it, but please give me probation, because then you're not accepting responsibility. So either you did it, what they charged you with, or you didn't. And doing it doesn't mean that you participated fully, and I'm sure Ms. Holmes has explained to you the law of parties in Texas and what that means. But if you say somebody took your car and you weren't even there and you had no idea of it, then that's what juries are for. Because you are about to take the chance, if we go forward, of me sending you to prison for 7 years, me possibly giving you probation. But I can assure you that you're not going to get any kind of help from me if you get up here and say, well, I didn't really do it, but come on, give me probation. Does that make sense?
Yes, ma'am.
So tell me, if you want to go forward, tell me exactly what you did, what your part of this was.
I was aware of what my car was going to be used for. I didn't participate in the act, but I...
So you didn't drive your car?
No, I did not. I did not drive it at the scene where it happened.
Mr. Nichols, it appears that the...
If I'm explaining myself, but
I think what she was trying to say, Your Honor, she wasn't present at the scene of the burglary, but let them use her car and I guess drove them close by. Because we know she was pulled over driving that vehicle on the way.
I mean, there's cameras from Lieutenant Hudson's cameras that confirm that you were driving when you were stopped
yes,
with the other guy seated in the
I
front
was in
seat.
town. I was in town when it happened, but I was not at the scene.
So, yeah.
So when did he get in your car?
When they brought it to the crime scene, but I was not at the crime scene.
I'm very confused.
So she drove here to Groves. She drove into town. She was aware of what was going to happen.
You weren't aware of it. You drove in to be a part of, you knew. I mean, there's saying I'm aware of whatever. Y'all came into town with.
Can I rephrase myself?
You probably should real quick, because hang on.
I was not at the crime scene.
Hold on.
Yes, ma'am.
Because y'all came into town with radio jammers and fully ready with medical mask and face mask and all this stuff to come in from out of town to do what you did here in our town. And so you weren't just riding along and then they said, oh, by the way, sorry you came with us, we're gonna do this.
Okay, well, I drove because I'm the one that had the license, so in case we got pulled over.
Okay,
I was not at the scene.
so you brought them to do the crime.
Yes, ma'am.
It's not that hard to say.
Yes, ma'am. I didn't know how to rephrase myself, I'm sorry.
All right, Ms. Holmes, go ahead with argument.
Yes, Your Honor. She does not have an extensive criminal history. As you can see, there is one prior, looks like a theft of property, which she received 6 months state jail. And then there was a federal case as well back in 2020. Ms. Zuli is currently employed and working. She would like the opportunity to continue that with probation. She does care for family members as well, Your Honor, for a household. As indicated in the PSI, they do have her at a low risk level, which I believe is indicative that she would be successful on probation if given that opportunity. They've also stated in the PSI that they would like her to.
For this, even though she was stopped and is on video driving the morning of. So I think the 7 years is appropriate. I'll note for the court, the co-defendant got 10. At least one co-defendant got 10. I'm not sure on the others. But I think 7 years is appropriate, and given the instance of this case.
This is a big twist of her. Probation means no conviction yet. But if she violates any condition, the judge can sentence her up to 20 years at his mercy, but with a trapdoor underneath.
How'd y'all pick this person?
Sorry.
How did y'all pick this house, this person, to come and,
No, like I said, the only reason why I came here was because I had the license. So in case they got pulled over, they didn't have a way to prove their citizens. So I was just like the one that drove into town. I don't know about
And if I can, 2 of those individuals have fled the border. They were not legalized, so they probably will never be found. So there were 2 other individuals involved, in which she has tried to get contact. So that's the reason why they were involved. She was the driver, but they have since fled and they're not coming back. That actually went into the house. There was only one that was caught that received a 10.
mm-hmm,
So I think that's what she's trying to say is she was driving because they obviously did not have the credentials to do that. And we don't know where they are.
so do you know why y'all came to this house?
I have no idea. The only reason that I came into town was because I'm the one that had the license. So in case they got pulled over, they didn't have a way, to prove their legal
How many
status.
other times did they have you drive you to other places?
No, that was the only time I did it, and I regret it. It was crazy.
Your Honor, if I may, I had the co-defendant's case. The victim in this particular instance was a local business owner, owned a donut shop. They also owned a donut shop and forgive me if I'm off on the exact city, I think somewhere in Humble, or nearby in Humble. That business, their home in that city was also burglarized.
Right. So, right. Thank you,
I
Mr.
can assure you I was not involved in any other situation that had to do with them. It was just a one-time thing.
How did you know these guys?
Well, basically one is my barber. The one that's doing time, he's my barber.
He's your brother? Barber.
Yes.
What about the other 2 that took
No,
off?
I never knew them.
So where do you live now?
I live in Houston, Texas. Yeah, Houston, Texas.
Do you work?
It's my
Where-
50 hours a week.
For what? For who?
It's integral. It's basically for the state. I get paid $25 an hour.
To do what? I'm sorry?
I don't know how to describe it. It's like solar panels. It's for the state.
Okay.
I have evidence as well.
You have what?
Evidence that I'm working there.
Okay.
Before that, I was working at a car wash, but they offered me more there.
So, I don't disagree with Lieutenant Hudson or with Mr. Nichols, because of what happened and the targeted way that this happened. It does appear that the guys were probably in charge of most of this. You made a really, really stupid decision.
Yeah. And I regret it.
Yeah. All right, what I'm inclined to do, because what you're charged with is a second-degree felony.
Just one.
So The range of punishment is up to 20 years if you went to jury, or all right, here's what I'm going to do. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. You're going to be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. So let me explain what that means and why that's good for you, but probably more so for me, and why I'm doing this. So a deferred probation means you don't have this conviction on your record. But what it also means is if you violate any condition of probation, you will be brought back into court, found guilty, so you have the felony conviction, and that cap of 7's gone. I have the full range of punishment between 2 years and up to 20 years. And certain cases, for whatever reason, the fact that this one, I remember it from Mr. Coleman's case, from the co-defendant, I'm likely to remember it. It's never good when I remember things, okay? And so I'm going to order also that you obviously have no contact or communication with any of the co-defendants. If they've fled the country, whatever, if they come back, if they try to contact you, you cannot have any contact with them. In fact, I'm ordering, if they contact you, that you contact your probation officer and law enforcement and let them know any information that you have about where they are. You will be, I want her on the medium-high caseload to start off with. It means you're going to be reporting more often, making sure you get off on the right track.
I work like an hour from my house, so I leave the house at 2:30 and come back home at 2:30 in the morning.
So talk to probation. I want you to work, okay? And so you need to get them documentation of your schedule, because there will be a curfew except for employment purposes. You'll be required to report in Harris County, but you're also going to be required to report by mail or online here. So you kind of have double duty. You've got to do it all. If you don't report by mail or online here, it's a violation. If you don't go in person there, it's a violation. If you don't give them proof of where you are when you're supposed to be, it's a violation. If you test positive for any drugs, whatever it is, you're going to be on a high caseload so that I know, at least for some time, that you're doing exactly what you're supposed to be doing. And if you don't, you will be right back in here. Do you understand? All right, I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she'll call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am.